Hello students, I am Vijayata from Postgraduate Teaching Department of Law, Nagpur University. In my last video, I covered the historical background of the Sexual Harassment of Women at Workplace Act 2013. In this video, we will see the salient feature of the Act. As discussed in the last video, Vishakha vs. State of Rajasthan was the landmark case that imposed responsibility and accountability on workplace. The three obligations imposed by the apex court guideline on the institution are prohibition, prevention, and redressal. With these three applications, Government of India came up with the Sexual Harassment of Women at Workplace Act 2013. Let's begin with the preamble of the Act. An act to provide protection against sexual harassment of women at workplace and for the prevention and redressal of complaints of sexual harassment and matter connected therewith and incidental thereto. The main feature of the Act are as follow. The Act defines aggrieved women under Section 2A, a woman or visiting a woman working or visiting any workplace, whether in the capacity of regular, temporary, ad hoc, or daily wages, are protected under this Act. Section 2F defines who is an employee. Sexual harassment at workplace is defined under Section 2N. Physical contact and advances or a demand or request for sexual favor or making sexually colored remark or showing pornography or any other unwelcome physical, verbal or non-verbal conduct of sexual nature will amount to sexual harassment at workplace. Section 2O defines workplace. Workplace includes all workplace owned by Indian or foreign company having place of work in India. It includes government organization, private sector, NGO, house, nursing home, educational institution, farm, sports facilities, hospitals, service providers, and cooperative societies. In this act, it is very important to understand what amounts to sexual harassment. Section 3 of the Act says that no woman shall be subjected to sexual harassment at workplace. The following circumstances, among other circumstances, if occurs or is present in relation to or connected with any act or behavior of sexual harassment may amount to sexual harassment. If implied or explicitly promise for preferential treatment in her employment, detrimental treatment in her employment, or threat of future or present employment status, or interfering with her work, creating an intimidating or offensive or hostile work environment for her, or humiliating treatment that likely to affect her health or safety, this will amount to sexual harassment at workplace. This act also provides preventive measures. The preventive authorities are employer, district officer, and most important, complaint committees. There are two complaint committees that needs to be constituted by the employer and by the district officer, that is internal complaint committee and local complaint committee respectively. This committee must have 50% of women representation and the committee will hold the position not exceeding 3 years. Every employer is obliged to constitute internal complaint committee. It will be composed of the following members. Chairperson shall be the women working at senior level as employee. If not available, then nominated from the other office, units, department, workplace of the same employer. Two members from amongst employees committed to cause of women having legal knowledge or working in social work. Member from amongst NGO associations committed to cause of women or a person familiar with the issues of sexual harassment. In the same way, district officer will constitute local complaint committee in every district. Chairperson nominated from amongst the eminent women in the field of social work and committed to the cause of women. Member nominated from amongst the women working in the block, taluka or tehsil or municipality in the district. Two members nominated from among such NGO association, person committed to cause of women or familiar with the issues relating to sexual harassment, provided that at least one must be women and at least one must have background of law or legal knowledge. Ex officio member will be the concerned officer dealing with the social welfare of women and child development in the district. Under this act, the employer and the district officer is obliged to create a workplace free from sexual harassment. It is their responsibility to create and communicate a detailed policies and also to ensure awareness and orientation on the issue, constitute a complaint committee in every workplace and district so that working women is provided with the mechanism for redress for their complaint, and ensure that complaint committee are trained in both skill and capacity and prepare and report and submit that report to the respective government. And lastly, the district officer will appoint a nodal officer to receive complaints at local level. Another pillar of the act is the redressal. First of all, who can make a complaint? Where a complainant is of physical incapacity, then the complainant's relative, friend, co-worker, any person who has knowledge of the incident with the written consent of the complainant can make a complaint to the complaint committee. In case of mental incapacity, then the complainant, relative, friends, special educator, qualified psychiatrist, psychologist, guardian, authority under whose the complainant is receiving treatment, any person with knowledge of incident jointly with any other person mentioned above can make a complaint to the complaint committee. In case of complaints, death, any person with the knowledge of the incident with the written consent of her legal heir can make an complaint. What should the complaint contain? Complaint must contain date, time, respondent's name, parties' working relationships. There are the steps which the complaint committee will initiate on receiving the complaint. Sexual harassment complaint process are as follow. First, submission of complaint within 3 months of the last incident. Notice to the respondent within 7 days from the receipt of the complaint. Completion of the inquiry by the committees within 90 days. Submission of report by the internal complaint committee or local complaint committee to the employer or district officer respectively within 10 days with the completion of inquiry. Implementation of recommendations within 60 days, and an appeal can be made within the 90 days of such recommendations. This act also provides for penalty up to rupees 50,000 if employers fail to constitute internal complaint committee or fail to act upon recommendation of the complaint committee or fail to file an annual report to the district officer required or contravening or attempting to contravene or abetting contravention of the act or rule. Lastly, the section 14 of the act deals with the false complaint. If the committee finds the complaints to be false, the act recommend the action against women or person who has made the complaint. It is also provided that mere inability to prove the complaint or inability to provide adequate proof need not attract legal action. Also, no action can be recommended against the complainant unless inquiry establishes malicious intent on the part of the complainant. In this way, all the workplaces in India are under obligation by law to provide a safe and secure working environment free from sexual harassment for all women. Thank you.